Good evening. So tonight we are going to be talking about special education, a comprehensive overview for families. Rachel and I, who are with McAndrews, Mehalick, Connolly, Hulse, and Ryan, will provide you with an overview, a comprehensive overview of special education. My name is Heather Hulse. Rachel Rosenberg is with me. We both know how much information is involved in the special education planning and programming for your children, and we know that it can be very overwhelming. We hope that this webinar will help you feel less overwhelmed and know that we are here to help. We represent families across the states of Pennsylvania and Delaware, many of whom we are able to represent at no cost for families. So please feel free to reach out to us with any questions, concerns. We will provide you with our contact information at the end of the webinar.
Oh, very good.
Okay, moving on. So the students with special education needs must be provided with what we call a free appropriate public education. In other words, a FAPE. This is pursuant to the Individuals with Disabilities Education Act. So tonight, that's much of what we're going to be talking about is with regard to the Individuals with Disabilities Education Act, and that is a federal law. It provides for students with special education needs to be sufficiently evaluated in all areas of educational need, identified in all areas of their educational need, and that they are provided an appropriate educational program or IEP to adequately address their complete educational needs. We're going to explain and break down these requirements of the IDA to provide a free appropriate public education to special education students and what exactly that means. So let's start with a broad definition of what is a free appropriate public education or FAPE. It is a program that is reasonably calculated to afford meaningful educational progress in all domains, academic, social, emotional, behavioral, physical, through a proper individualized education program or IEP. So what this means is that each IEP for each special education student must be developed to fully address the complete educational needs of each student. And then it must be implemented. At times, it is falsely believed that a student must struggle academically in order to be identified with a special education need. As you will hear tonight, the IDA requires that students with special education needs must be evaluated in all of those areas of need, identified in all of those areas of need, and that those needs must be addressed. And while, of course, academics can certainly be a major part of special education, it can be an area of need. Indeed, we're going to talk about and you're going to learn about specific learning disabilities as well as other areas of special education eligibility. But a student must also be afforded meaningful educational progress in non-academic areas as well, such as socially, emotionally, behaviorally, developmentally, in areas of speech and language, and in areas of occupational therapy.
So the IDEA lays out the different categories that show that will provide for eligibility under the IDEA. So in order for a student to be eligible for special education services under this act, they need to fall into at least one of the 13 categories laid out under the IDEA Act. So these are all the different categories are listed here and on the next slide, which I'll go to in a moment. But they include autism, deafblindness, deafness, emotional disturbance. Hearing and emotional disturbance covers a range of mental illness concerns like anxiety, bipolar, oppositional defiant disorder, variety of things like that. Hearing impairment, intellectual disability, multiple disabilities. So this means that a student may have multiple disabilities that are included in this list, and that student's needs can't be accommodated through accommodations for just one of those disabilities. It needs to be a specialized way of approaching education to combine both of those disabilities. So an example of that would be intellectual disability and blindness, for instance. Another category is orthopedic impairment, and then other health impairment, which is seen kind of as a catch-all. One common disability that falls under this is ADHD. Specific learning disability, Heather touched on this briefly a moment ago. This is the most common eligibility category, and this is what, most commonly is thought of when you're thinking about special education, those learning disabilities. So that could be a specific learning disability in something like reading comprehension or written expression or math or any of those academic needs that you could think of. There's also speech or language impairment, traumatic brain injury, visual impairment, and developmental delay. And developmental delay is the only eligibility category that's actually age barred. Only somebody 9 years or younger can have this category, and it's relating to developmental delays from birth until that point. So in order to be eligible, as I said, in order to be eligible for special education services, a student would need to fall under at least one of those categories. But in addition to that, not only would they need to have one of these disabilities, they would also need to show that they're in need of special education services or especially designed instruction in order to make progress or access their education.
So also along the lines of what is entailed in a free appropriate public education, the IDA requires that students must be educated and their needs must be met in what's called the least restrictive environment, or LRE, consistent with their needs. So this means that special education students must be educated with typically developing peers to the maximum extent appropriate. The law provides that we essentially start with thinking about the regular education environment and working our way out, again, consistent with what the student needs. So we may not necessarily start by placing a student in the regular education setting during the school day, but it means that we consider the least restrictive environment that would be appropriate for that student. So again, meeting environments with their typically developing peers to the maximum extent appropriate. That's what we want. So for example, this does not mean that all students with special education needs should be educated in a regular education setting all day, because again, it must be consistent with their needs. Nor does it mean that we place all students who are identified with autism in an autistic support class all day. It means that each student's individualized educational needs are considered in determining the student's placement throughout the school day. So this means that you may have a student who has been identified with a specific learning disability in reading or written expression, for example. And so perhaps they need a learning support environment for English language arts. Perhaps they need to be educated, receive some research-based reading instruction for part of their school day. Sometimes it's called a what I need or a resource room period. And then they're in regular education settings for the rest of their school day. Or it may mean that a student is in life skills setting. For example, let's say you have a student that's identified with intellectual disability, and they might need life skills support for reading, math, perhaps some social skills instruction, but then the student can receive their education in the regular education setting for science, social studies, specials, lunch, homeroom. So again, least restrictive environment is going to be based on what that student's needs are, but we do want them with their typically developing peers to the maximum extent appropriate. Separate schooling, special classes, other removal of special education students from the regular education environment should only occur if the nature and severity of the disability is such that education in regular classes with the use of supplementary aids and services cannot be achieved satisfactorily. So this means that the IDA requires the full range of supplementary aids and services. And Rachel's going to talk more about that later, what those look like. But they must be implemented in a regular education setting rather than, oh, well, the student is identified with emotional disturbance, so let's automatically remove them and put them into a more restrictive emotional support classroom or even outside the district into an emotional support school. For example, if we have a student that's demonstrating social, emotional, and behavioral needs, they may not necessarily need to be placed in an emotional support setting at all for their classroom instruction. They may. It again depends on the nature and severity of their need. And schools are certainly required to provide such services such as research-based school social skills instruction or research-based coping skills instruction during a non-academic period of the school day before that student would be removed from their regular education school setting. It also means, for example, that a one-on-one aid could be provided in a regular education setting rather than moving that student into a more restrictive emotional support setting, for example. So the Third Circuit Court of Appeals specified that school districts must consider, as I mentioned before, the full range of supplementary aids and services that can be provided in that regular education setting and must make efforts to modify that regular education setting to accommodate a special education student. So this is a landmark court decision called O'Berty versus Board of Education that discusses least restrictive environment. Not only does it discuss the requirement of consideration of the full range of supplementary aids and services, schools are required to make those modifications to the regular education program if necessary. The O'Berty Court also very beautifully discusses how the concept of least restrictive environment is not only a great thing for students with special education needs. So again, we want special education students to be with their typically developing peers to the maximum extent that they're able to. We also want special education students to be in the least restrictive environment for typically developing students as well, because it helps typically developing students to learn to understand and be more accepting of students with learning differences. And the O'Berty Court does touch on that. The IDEA specifically provides that special education students should not be removed from education in an age-appropriate regular education classroom solely because of the need for modifications in the general education environment. So again, if the school district or charter school needs to make modifications to that regular education environment so that a special education student may be appropriately participating with their typically developing peers, then they're required to do so. Accommodations and supports must be provided as necessary to make meaningful educational progress to allow maximum integration with non-disabled peers to participate in extracurricular and non-academic activities as well. So that requirement for providing accommodations, the full range of accommodations and supports carries over into after school activities and field trips, for example. So modification support services should be provided so that special education students or students with special education needs can participate in extracurricular activities and field trips. I can't tell you how many times I've had parents come to me and tell me that their child was not permitted to go on a field trip due to their they can't accommodate their social, emotional, behavioral needs, for example. They are required to accommodate those needs so that your child can participate in field trips with their typically developing peers.
Child find is the state's responsibility to identify students with special education needs. So I can't tell you how many times I've had conversations with parents who blame themselves for not getting help for their kids sooner. And it is completely not on the parents to make that request. The school districts are required, and the state must have in effect policies and procedures to ensure that all children with disabilities residing in the state, including children with disabilities who are homeless children or children with disabilities attending private schools, regardless of the severity of their disability, and who are in need of special education and related services, are identified, located, and evaluated. So again, it is not the responsibility of the parents to request an evaluation, to let the school district know that they think their child might be experiencing some learning difficulties or access to the education. It is completely up to the state to make that finding and to evaluate students based on that finding. So a child find must include not only children who have one of those eligibility categories that we talked about earlier, but also children who are suspected of that, children who have not yet been identified. So children who are suspected of being a child with a disability and in the need of special education, even though they are advancing from grade to grade, and highly mobile children, including migrant children. So if a child is going from grade to grade and seemingly meeting grade level curriculum, that doesn't necessarily mean that they don't need special education services. So a state is required to find those children who need to be evaluated to see if they do need additional supports in order to fully access their education and get the FAPE that we've been talking about. And that includes all children, including mobile children, children who are moving place to place, children who are experiencing homelessness. No child is free from being entitled to these types of supports, and the school district and the state is responsible for all of them. So that being said, the state is responsible for finding those children and then evaluating them. And evaluating each child with a disability, an evaluation must be sufficiently comprehensive to identify all of the student's special education and related service needs, whether or not commonly linked to the disability category in which a child has been classified. So earlier we went through all the different eligibility categories. So if a student is eligible under autism, that doesn't necessarily mean that they don't have other needs that need to be considered and evaluated as well. So evaluations need to be comprehensive and evaluate all potential areas of need so that a school district can be aware of any area of need a student may have, whether or not it's related to their eligibility category, and then accommodate accordingly. So the initial evaluation is required when there is reason to suspect that a child has a disability and needs special education. So this could either come, as early intervention before a child has even started school, or anytime before a child has started receiving special education services. And then additionally, I should have mentioned this on the last slide, but after that initial evaluation, the school district then has a continuing obligation to reevaluate. So because as a student grows, their needs change and grow. So every 3 years, a school district is required to do a reevaluation, which also needs to be comprehensive, to see how the child is progressing, see how their needs are progressing, and then make any updates accordingly. And while a school district is required to reevaluate every 3 years, they can do so once a year if they have reason to and if appropriate.
And just to add, if the child's identified with intellectual disability, they're actually required to be evaluated every 2 years.
Thank you. Yes, thank you for adding. Okay, so independent evaluations. Parents have a right to obtain an independent educational evaluation, often at the public expense. So the evaluations that we were just discussing are evaluations done by the school district, typically the school psychologist that either works for the school district or that the school district contracts with. Sometimes parents have a right to obtain an independent educational evaluation done by somebody who doesn't work for the school district. And this could be done at public expense if the parent can show that the school district's evaluation, either that the school district failed to do its own evaluation or that its evaluation was deficient, meaning it wasn't comprehensive enough. It didn't cover X, Y, and Z. It should have done this. It should have done that. So if a parent can make a showing, and that's something that we do a lot as attorneys in this field, is that we'll request independent educational evaluation showing that the school district's evaluation was deficient for certain reasons. And if you make that showing, the school district will then have to pay for an independent educational evaluation.
So after a student is sufficiently evaluated, as Rachel just discussed, a proper IEP must be developed, an appropriate individualized education program. So an IEP is essentially, it's a written statement for each student with a disability. It's developed, reviewed, revised in meeting with parents, guardians, and relevant professionals. An IEP is annual. It must be, after it's developed, it must be reviewed annually. However, it can certainly be reviewed and revised as needed. So if your child's IEP meeting, for example, let's say happens in early September, you and the IEP team develop what is believed to be an appropriate educational program for your child. But then by November, December, you're not seeing that meaningful progress that you were expecting to see. You can request an IEP meeting to discuss the concerns you have with the lack of progress. You can talk with the IEP team about making revisions to address those concerns. So for example, perhaps a different research-based program needs to be implemented. So for example, let's say your child has a reading disability and a reading program is being implemented to address their reading comprehension needs. Lo and behold, we find out that your student's really struggling in this decoding needs. So we need to change gears and look at a research-based program to address those decoding needs. And maybe that's why the student's not making progress, because the research-based program isn't really addressing those specific needs of your child. We're going to go through the IEP components, the parts of the IEP. So early on in the IEP, there is a statement of the student's present levels of education and academic performance. In that section, this should tell you, uh, the IEP team, anyone who's implementing this IEP will be reading this IEP. You want them to have a very good understanding of what your child's educational needs are and where their strengths are and where they're functioning. So that would be in terms of how your child's functioning in areas of academics as well as in functional performance. So for example, if they have reading needs, where are they functioning? Is decoding an issue? Is fluency an issue? Is comprehension an issue? And where are they functioning in all those areas of need? If they have math needs, is calculation the issue, or is it more problem solving? Where are they functioning in both of those areas? If they have emotional needs, where is your child struggling? Maybe they're struggling in being able to identify when they're feeling these emotions. Maybe they're struggling to identify the emotions. Maybe they're struggling to regulate those emotions. So where specifically is the child struggling, and how is that child progressing in those areas of need? A statement of measurable annual goals, including academic and functional goals. So this is the next section and a subsequent section in the IEP. The goals must address every area of need. They must be measurable. So that means that we need to know if that child is making progress in the specific area. So when we say a measurable goal, we should be able to tell by the goal itself if we're looking at the baseline And then the progress monitoring over time, is that student making progress? That's what we mean by measurable. So, for example, you wouldn't have a goal that says um, the student will improve in math calculations. Well, every student, the goal was to improve in math calculations. Where specifically is that child functioning in math calculations when we develop the IEP? And then where do we expect them to be at the end of that annual IEP? And then there should be progress monitoring along the way. Also in that goal section is a description of how the child's progress towards meeting the annual goal will be measured. So, what methods of measuring progress are we using? Are we using a curriculum-based assessment? Oftentimes, school districts will use Ames Web curriculum-based assessments. Are we collecting behavioral data to measure the behavioral progress of a student? Are we using some type of research-based program, and maybe the research-based program itself has a progress monitoring tool? So the IEP should describe in that goal section what is the method for measuring the student's progress. I used to see, not so much anymore, but I used to see where school districts would say things like progress monitoring to describe the child's how we're monitoring. That's not sufficient. Of course, for progress monitoring, it should be how specifically is that progress being monitored in that particular area of need. When the periodic reports will be provided to the parents should also be indicated in that section of the IEP. So you will often see things like quarterly. They will provide it with the report cards. So often parents will get an IEP progress monitoring quarterly. That does not mean that quarterly is sufficient. It may be sufficient reporting period for IEP progress monitoring. But I would suggest that certainly for a student that has at least significant behavioral needs, we don't want to be waiting until the end of a quarter to be reporting that whether or not the student has made progress to the parent. And we should have more frequent progress monitoring for example, any kind of behavioral need. A statement of special education related services and supplementary aids based on peer-reviewed research to the extent practicable, but when is it not practicable? And a statement of the program modifications and supports for school personnel. This also needs to be included in the IEP. So what related services are going to be provided to the student? Speech and language, occupational therapy, physical therapy, counseling services. Those are all examples of related services, and Rachel's going to touch on those a little bit more. But we need to explain the duration and the frequency of those services. And they should be based on peer-reviewed research. So, for example, and the IDA says to the extent practicable, but again, when is it not practicable? There are research-based programs that are readily and easily available in all areas of need. There are research-based programs in all areas of academics and social skills instruction, coping skills instruction, in areas of behavior, executive functioning. So again, I encourage parents to push for that type of research-based programming and direct instruction in students' areas of need. And then a statement for the program modifications and supports for school personnel. So often in this section, you will see that copy of the IEP will be available or provided to the staff members who are implementing the IEP. You might also see things like consultation between the regular education teacher and the speech and language therapist. And those are great. Those are fine to have. But I also like to see things, some other supports for school personnel, particularly when you have a disability that may not be as commonly understood, by school district staff. So I'm just going to give an example of a matter. I had a student I had that was diagnosed with Tourette's syndrome, and he was identified under the IDEA under other health impairment. And many of the staff members were not really educated in Tourette's and have a comprehensive understanding because it's not something that we commonly see. So I advocated for, and the district did ultimately agree to have in that program modifications and supports for school personnel to have somebody who's qualified to come in and do a teaching seminar so that the staff who are implementing that student's IEP now were educated in that student's specific disability and how that's going to impact their education, how that's going to impact them in the classroom. So that's something that I think we need to sometimes be thinking outside the box. Okay, and an explanation of the extent, if any, to which student will not participate with their non-disabled peers in the regular education setting or in other activities. So every IEP will have, and this is towards the end of the IEP, it will explain how much time the student is spending outside of that regular education environment and how much time they're spending in that regular education environment. So the parent has an understanding of at what periods of the day will the student be functioning with their typically developing peers, participating with their typically developing peers, and what parts of the school day they will receive special education services or be in a special education setting. A statement of individual appropriate accommodations that are necessary to measure academic achievement and functional performance of the student on state and district-wide assessment. So every IEP will have there's a section in the IEP that will explain if they need any accommodations for state or district-wide assessments. So for example, the PSSAs are given every certain years of a student's educational career. And there are accommodations that can be implemented. Now, you're not going to be able to get all of the accommodations that are in an IEP that would be implemented during the school day. So, for example, we want to assess the student's reading needs, in when we're assessing PSSA, they may not have that accommodation that you would have in a regular school day to accommodate those reading needs. But questions can be read to the student, for example. They won't be able to have all of those special design instruction accommodations, but you may see things for accommodations and for PSSAs like extra time, questions being read, calculator for the non-calculation sections of the math component. So, and testing in a distraction-free environment.
Okay, so another component of the IEP are supplementary aids. So Heather talked about this a little bit in the conversation about least restrictive environment. But supplementary aids are aids, services, or other supports that are provided in the regular education classroom and other education related settings and in extracurricular and non-academic settings as well to enable students with disabilities to be educated with non-disabled peers to the maximum extent possible. So a lot of these are accommodations that can take place in the regular education classroom, not just in a separate special education classroom or in a separate school. So lots of examples are listed here. But some of them include direct instruction in a small group setting using multisensory research-based programming, direct instruction in executive functioning using research-based programming, direct instruction in a variety of different areas using research-based programs, a one-on-one aide who can be included in the general education classroom, scheduled and unscheduled breaks throughout the day, access to a guidance counselor, extra time for assignments, tests, or homework. These are all examples of supplementary aids that can be included in an IEP and that will allow a student to be in the least restrictive environment. Some more examples here include reduced assignments, providing copies of teachers' notes, providing completed study guides at least 5 days prior to a test. There are a variety of testing accommodations that can be included for students who have trouble with testing. Visual, verbal, or nonverbal prompting to remain on task and complete tasks and to refocus. A student could be provided with choices wherever possible, reinforcing positive choices made, consistently catching good behaviors, and these kind of coincide with a positive behavior support plan. So as we discussed, some of those disabilities that are related to a need for special education can be related to behaviors in the classroom. And there are so many accommodations that can be put in place to help with those behaviors so that a student doesn't need to be pulled out of the least restrictive environment. And Heather will talk more about a positive behavior support plan in a bit. So another component of the IEP are related services. Heather also touched on this earlier, and some of these related services do involve getting pulled out of the regular education classroom for sessions. But these are services that can be required to assist a child with disability to benefit from education. So that includes audiology, counseling, occupational therapy, orientation and mobility services, early identification and assessment, interpreting services, diagnostic medical services, parent counseling and training. I mean, sometimes there are a lot of accommodations that require parents to get trained at home, especially for things regarding technology. So assistive technology is something we'll talk about, but there's a ton of technology out there that can be used in the educational setting to help your child. But they're not always intuitive. And sometimes the staff and personnel at school need training on these technologies, and so do parents. So that can be something included in the IEP. Physical therapy and social skills are also common related services that are included in IEPs. More related services are listed here. Psychological services, recreation, rehabilitation and counseling services, social work services, school health services and school nurse services, speech language pathology, and then transportation. And transportation isn't always thought of immediately when you're thinking of related services. You know, you typically are thinking OT, speech, different things like that, but transportation is also a related service. A lot of students with special education needs require specialized transportation, whether that is door-to-door transportation on a separate bus or accommodations on the general education bus, preferential seating on the bus and aid on the bus. There are a variety of transportation related services that should be included in the IEP if appropriate. An IEP can also consist of a transition plan and must include this for students who are age 14 or older. So transition is, there should be a roadmap for any post-secondary goals to outline the services and activities to help prepare a student for life after high school. So from the age of 14 on, there must be based upon appropriate transition assessments, which are specifically designed to improve the child's academic and functional achievement. Services must be designed to facilitate the child's movement to post-school activities. So this is, as is the entire IEP, individualized based on a given student. You assess a student and see what that student's goals are after high school. If that student plans to go to college, then the transition plan should focus on getting a student ready for college and how to handle college after graduation. Some students don't plan to go to college, and then you might want to look into vocational training, life skills, independent living skills. There are a variety of transition plans that can be put into place early on to do everything that can be done to help a student after they leave the secondary education setting.
So positive behavior support, when you have a student that is demonstrating behavioral needs that are impeding upon the learning of themselves or others, a school district or charter school is required to first complete a functional behavior assessment and develop a positive behavior support plan. So we want to be reinforcing good behaviors, those positive behaviors. So, positive behavior support plan must be based in research. We want anything that we're implementing to be based on peer-reviewed research, meaning that it has been proven to be effective. It must be based on a comprehensive functional behavior assessment. So this is usually completed by either a certified behavioral analyst or a behavioral specialist or a school psychologist. And it consists of first, the team would identify the behaviors of need, and then it would consist of a series of observations over time and in a variety of settings. So we want to determine what are the function of the student's behaviors. What are the antecedents? What's happening before? And what's reinforcing that behavior? So you may learn during a functional behavior assessment that a student is perhaps they're struggling behaviorally in classes that are less structured and that they do better in a more structured setting. So we that helps us determine that the function of the behavior is being in that less structured setting. You may learn that a student struggles with particular peers in their classrooms or a particular staff member, they struggle more. Perhaps they struggle more in classes where there's more reading, and lo and behold, you learn that there's a reading issue, and that's why the student is struggling. So, functional behavior assessment can really help us determine what is the function, what is supporting that behavior, and what's reinforcing it. If a positive behavior support plan must be based on positive reinforcement. So again, we want to be positively reinforcing those good behaviors, identifying what those good behaviors are and reinforcing them. The interventions that we use must be the least restrictive, least intrusive necessary. So if we are using some type of intervention, again, we want to be doing that in the least intrusive manner as possible. Restraints. So often, not often, but sometimes students need to be restrained when there is a clear and present danger. So if they are a danger to themselves or others, and that is the only time that students should be restrained. You should never be implementing restraints when a student, just to manage behaviors, for example. So it is only in situations where there is a clear and present danger. uh, it should only be implemented by trained staff. So I've had situations where staff have intervened that are not trained in restraining students, and that's certainly problematic. Once a student is restrained, there must be a written notice of restraint provided to that parent. That must happen relatively quickly. Um, I certainly like to see that within the first 24 hours. The IEP meeting must be offered. So a student's parents or guardians must be offered an IEP meeting to occur within 10 days of that restraint. The IDEA and the Pennsylvania law regarding regarding positive behavior support is we don't want to be restraining students over and over and over again. So we want to be working towards the plan of not restraining students. So there, first of all, restraints must be used in conjunction with teaching socially acceptable alternative skills. If you do not see any implementation of let's teaching that child to behavior appropriately, we there's a problem. because we shouldn't be just continuing to restrain to address those behaviors. It must be used in conjunction. Well, let's help to teach the student how to behave appropriately. And again, there are research-based programs to help with that. In addition, next slide, the positive behavior support plan also must have a plan to eliminate the use of restraints through positive behavior support. So if there is implementation of a restraint for a child, we must have some sort of plan to so that we're no longer going to be using those restraints. There must be a plan to eliminate the use of restraints. No prone restraints. I must tell you, I have not seen that in quite some time. That would be a face down restraint. No punishment for manifestation of disability. So this is a big one, and this is required by Pennsylvania, that a student cannot be punished for a manifestation of their disability. So if they're and there's a manifestation determination process. But if that student has a disability, say, for example, they have attention deficit hyperactivity disorder, and it impacts their ability, their impulsivity. They don't think, they think impulsively, and they don't always think about things and think about the consequences of their actions. We often see students that will engage in behaviors as a result of their impulsivity related to their attention deficit hyperactivity disorder. And in that case, we don't want to punish a student. It doesn't mean that we can't use that as a teaching opportunity and help them educate the student, work on their impulsivity, working on coping strategies and strategies for them to be able to overcome. But the law requires that there should not be punishment for any manifestation of a disability. No locked room or room where exit is prevented. So your child should not be put into a room where they are not permitted to exit if they want to exit. We shouldn't be closing doors on them and holding them in rooms, or even standing in front of those doors and preventing them from exiting. Yes, eloping can be a concerning behavior, but there are other ways to address eloping other than placing a child into a room and preventing them from exiting. Appropriate ways. Suspension for more than 10 consecutive days, so 10 days in a row, 10 school days, or 15 cumulative school days, so 15 days over the entire school year, is considered a change of placement, and a parent must agree with that. There are exceptions to that. If a student brings drugs or drug paraphernalia into school, brings a weapon into school, or commits serious bodily injury against another person, they would be those exceptions. And in those cases, a school district or charter school can unilaterally, without the parent's consent, place that student, that special education student, into a what's called an alternative educational placement for up to 45 days. During that time frame, they do still need to provide a free, appropriate public education to that student. And truancy, I like to touch on truancy in the IDA because it does happen from time to time where special education students, for maybe having to do with their behaviors, maybe having to do with anxiety, struggle with attending school, and can be subject to consequences of truancy. So if a student with special education needs is truant, it's really important for the school district to conduct social emotional assessments and or a functional behavior assessment to determine what is the reason behind the truancy. So, for example, if you have a student that's really struggling with anxiety, it's not per se truancy. It's that is a student that has a special education need that must be addressed. And punishing the family for truancy isn't an appropriate way to address when a child has anxiety. I've seen students flourish when we appropriately address anxiety by implementing provisions of, if you have a student that's refusing to come to school at all, well, then maybe we can get that student to come to school for part of their day. Let's try getting them to class, to one class. Let's them in for counseling services, and maybe implementing counseling services in the home, and trying to get them to transition into the school day. There are many ways in which a student's anxiety can be addressed rather than filing for truancy. And also, results of those assessments should be utilized to develop an appropriate positive behavior support plan that can help address that truant behavior.
So as I mentioned earlier, when I was talking about the eligibility for an IEP, to be eligible for an IEP, you need to meet one of those categories that we discussed, and then the student also needs to require specially designed instruction to access education. Now, sometimes if a student meets one of those categories but doesn't require specially designed instruction, they may be eligible for a 504 plan. So not only that, but Section 504 actually has a broader definition of an individual with disability, broader than those categories that we went through for an IEP. So under a 504 plan, an individual with a disability is any person who either has a physical or mental impairment, which substantially limits one or more of such person's major life activities, and learning is a major life activity, or has a record of such an impairment, or is regarded as having such an impairment. So if a student falls under one of these categories, then they're entitled to a 504 plan. And a 504 plan and Pennsylvania's Chapter 15 require a service plan with special education services and related services. So 504 plan is similar to an IEP plan, or an IEP, but it just it doesn't allow for direct instruction and measurable goals, but it does allow for a variety of accommodations that can assist a student with a disability that doesn't necessarily need those goals to track the progress. So these are services that remove barriers and ensure equal access to the general education curriculum, and can include any accommodation without a measurable goal. So some examples include extended time on tests, or any of these testing accommodations that we've been talking about. Preferential seating in the classroom if it's helpful for a student to be in the front row to focus. Assistive technology that we talked about earlier, like hearing aids or speech to text technology, headphones, anything that can accommodate a student in the general education setting can be included in a Section 504 plan, and might be really beneficial for a student that has needs but doesn't quite qualify for an IEP plan. So remedies under the IDEA Act, and this is where we often come in. So as we've talked about today, the IDEA Act requires schools to provide a variety of services to ensure that all students have a free and public and appropriate education. If the school is not doing this, then you are entitled to a variety of different remedies depending on what the school is failing to do. So for instance, you could demand an appropriate program or placement be put in place. So if the setting isn't appropriate, let's say that the least restrictive environment for a student isn't the general education classroom, but it's a separate autism support classroom, or maybe it's even a completely separate school. One of the remedies under this act is to make a demand for the appropriate program or placement. Likewise, school districts might be required to provide reimbursement for tuition and related costs for private placement. So again, if the least restrictive environment provides that a student needs to be in a separate school, sometimes a school district can't accommodate for a student. But a school district's inability to accommodate for a student does not mean that they're not responsible for accommodating for that student. It means that they need to allow that student to be in a setting where it can access its needs. So sometimes they are required to reimburse the cost of private school if the public school is not able to provide for those needs. There's also something called compensatory education. So this means, this basically is addressing past failures. So if it can be shown from looking at the progress monitoring that we spoke about, that the school district has failed to properly accommodate a student. And you can show that through the lack of meeting goals, or that they didn't have certain goals where they should have had goals, or certain services should have been in place and weren't in place. In order to make up for those failures the school district has caused, you could be entitled to compensatory education. So that's a fund of money that is held by the school district to make up for those failures. And those funds can be, you can access those funds for educational services to make up what they've failed to provide in the past. So those funds can be used for really anything that, varies case to case, but largely anything that is related to the student's education. So it can be used for tutoring. It can be used for vocational training. It can be used for assistive technology or computers or iPads. It can be used for counseling or speech therapy or OT, anything that is related to the student's education that makes up for the school district's failures to provide that FAPE. And that's something that we do a lot. We will make demands to the school district to provide that compensatory education for their failure to properly accommodate for a student. We can also request reimbursement for out-of-pocket costs associated with providing educational services, like some of those things I just talked about. If you have already paid for your own tutoring and your own OT or speech and language therapy, oftentimes that can be reimbursed if you can show that those things were needed because the school district failed to properly provide the speech and language that they should have been providing, or appropriate reading services that would have meant that you didn't need to pay for tutoring on the side. Like we mentioned earlier, one remedy is an independent educational evaluation. If you can show that either a school district failed to evaluate your student, or the evaluation that they did was deficient because it wasn't comprehensive enough, or failed to test for a variety of things. And then you can also seek an initial evaluation from the school district if they haven't evaluated. So if you have any questions, or if you're interested in anything that, that we've discussed, what we do at McAndrews, McAndrews law offices is represent families to assist them with everything that we've talked about today. So if you have any general questions, you can always feel free to reach out. And our team will be there to either answer your questions or schedule consult meetings with the attorneys to talk about your needs. And we have offices all throughout the state of Pennsylvania and in Delaware and DC as well. And we're always here to answer any questions that you have. So thank you so much for joining us. And if you have any questions, please reach out.
Thank you.